So if a parent suffers from mental illness, if they suffer from a mental disability, the court must assess whether that illness is going to interfere with their ability to parent. It's not a question of if they should or if they couldn't. This is something that must be considered. The simple fact of seeking custody of a child places the parent's mental health and physical fitness to parent at issue. A disability alone is not enough reason to deny a parent custody. You can't just say, oh, they suffer from this disorder, that's enough. You're going to have to show specifics as to what the signs, what the symptoms are, and how that disability impacts them and why they're unfit to parent. So it's not something to say, oh, they have this, then it's done, it's over, we resolve the case. No, you're going to have to show not they have that and then what the impact is and why that prohibits them from having custody. Primarily, what a court likes to see is that they respond much more favorably to a parent that has an issue and is addressing the issue, is seeking treatment for the issue, is complying with the medical advice, taking their medication if possible, seeing a therapist on a regular basis. The court views that in a very favorable light. It's more favorable to be in that situation than to be in a situation where you're undiagnosed or you're not seeking treatment or you're not doing anything and all the signs and all the symptoms are there and it just lays out a pattern of reckless or inappropriate behavior that's not going to lend itself to the court giving a custody determination on your behalf. The court's more likely to see somebody that has a disorder, that is seeking treatment, that is speaking with a therapist, that is complying with all the recommendations of that therapist, and actively seeking to better themselves as a person, as a parent, as opposed to somebody else that might think, oh, well, if the court's going to get a hold of these records and they're going to see what's going on, there's no way I'm going to get custody if they see I suffer from schizophrenia or they see I'm bipolar disorder or whatever the case may be. All the symptoms are still going to be there regardless. So if the court sees a pattern of erratic behavior, if they see text messages, if they see eyewitness reports, if they have anything that could be going on, police reports, hospital reports, and things along those lines, the court's going to know that there's some sort of underlying issue going on there anyway. So if that parent, if that is seeking to deal with that issue and address it head on and do the best that they can do, the court's more willing to look at that in a more favorable light than somebody that's just denying it. Again, same thing. If that mental illness, however, makes it impossible to provide a safe environment for the child, the court may determine that they need to limit the access to the child and possibly even just order supervised visits where they don't think it's safe for the child to be left alone unattended with that parent. Medical history, treatment, and cooperation is all relevant in making the determination, and that's not just limited to current events.